Hi everyone, my name's Lori Dubin. I'm an associate family lawyer at Russell Alexander's office. Welcome to our YouTube channel, where we cover current family law news stories and other topics related to divorce. We upload videos twice a week. You can subscribe and hit the bell so you don't miss an upload. Today we're going to discuss pot lace cookies and secret recordings, how to split parenting time between immature parents. The court began the decision this way: one cookie and just a nibble or two. That is all it took to weaponize the parties' separation. Unfortunately, it was not just an ordinary cookie. It was a laced one with marijuana, and the person who took the nibble or two was the party's 4-year-old child. That was enough to set off the explosion of recrimination and blame shifting that led to this motion. The cookie that the child sampled from had belonged to the father. She had found it in his toiletry bag while in the parents' bathroom. Upon discovering that the child had done that, the mother had an ambulance rush her to the hospital, where the examining doctor nonetheless concluded there was no significant risk to the child's health. The mother's next move was to search the father's bedroom, where she found a Tupperware container of marijuana in his gym bag. Having concluded the father was reckless, she unilaterally and surreptitiously removed the child to her parents' condo. She then withheld the child from the father and refused to even tell him where she had been taken. She justified this one on the basis that the father posed a threat to the child. The matter came before the court, with the father asking for interim primary care of the child. The mother countered with a request for primary care as well. The court began by noting that its focus was to remain on the best interests of the child at all times, but added, the list of best interest factors is not a checklist to be tabulated with the highest score winning. Rather, it calls for the court to take a holistic look at the child, her needs, and the people around her. Next, the court observed that while recent changes to the Divorce Act had removed the maximum contact principle, the notion that a child should have as much contact as possible with each parent is still an important part of the court's best interests of the child considerations. This doesn't necessarily mean that the parents should enjoy equal parenting time. Rather, each family is different, and the principle is a guide set out to benefit children. In this case, the court expressed concerns about both parents' behavior towards each other. For one thing, each had surreptitiously recorded the other. However, the court refused to listen to such evidence, noting that they were only to be used in exigent circumstances with extreme caution in family litigation. Also, the parties' behavior around the pot cookie incident didn't help. The father exercised poor judgment in leaving his marijuana where the child could find it, and then underplayed the incident. The mother overreacted, and then used the subsequent Tupperware discovery as an excuse to remove the child from the home, change her residence, and cut off the father's contact. These self-help measures reflected poorly on her own parenting skills and judgment. The court admonished the parents with these words: both parents have acted badly and immaturely towards each other. Each has secretly recorded the other multiple times. The mother has twice attempted to secretly surveil the father using a GPS device. Their child needs them to grow up and find a way to act better towards both each other, and by doing so, towards her as well. In the end, the court rejected the mother's parenting plan, which involved a schedule that saw the father and the child being kept apart for a 9-day span at various points. It also refused the mother's request for permission to change the child's residence to Toronto, as she requested. The court preferred the father's more child-centered, shared time proposal. Since the time away from either parent was 3 days at a maximum, and it included each parent having 15 minutes of video contact with the non-residential parent each day, all of which was in the child's best interest, the court concluded. That's it for today's video. If you like this video, please give it a thumbs up so we know what kind of videos you want to see more of. Comment below, did you agree with the judge's decision? Please subscribe and hit the bell icon. We upload about twice a week. Thank you for watching.